The Assembly Committee on Government Affairs will come to order. Mr. Secretary, please call roll.
Assemblywoman Anderson. Assemblywoman Black. Assemblywoman Brown May. Assemblywoman Considine. Assemblywoman Dickman. Assemblywoman Duran. Assemblyman Ellison. Assemblywoman Martinez. Assemblyman Matthews. Assemblyman MacArthur. Assemblywoman Thomas. Assemblywoman Torres. Chair Flores.
Present. Thank you, Mr. Secretary. Please let the record reflect all members are present. We have a quorum. Good morning, everyone. To those of you following us virtually, welcome to your hardworking Committee on Government Affairs. We have a very exciting day today, as always, in this committee, with a lot of enthusiasm, and I know we're going to have a lot of questions. We have two items on the agenda today, Senate Bill 38 and Senate Bill 372. We're going to take them in that order. For those of you wishing to join us for public comment, please know that we'll be doing that at the conclusion of today's meeting. Members, I want to remind you that please make sure that you are not logged in via Zoom and that you are in the committee room. We want you to either be in the committee room or logged in via Zoom, but not both, as it will cause chaos behind the scenes. Everyone wishing to testify today before the committee, I want to remind you to please state your name after each question. That's not for our sake. It's for you to help our hardworking staff to ensure that they can properly take minutes. So please, after each question, please make sure you state your name for the record each and every time. And with that, we're going to go ahead and get the agenda started, and we'll open up the hearing on Senate Bill 38. And I know we have both Ms. Adair and Mr. George, whenever you're ready, please.
Good morning, Chair Flores, members of the committee. My name is Kyle George, and I'm the First Assistant Attorney General with the Office of the Nevada Attorney General. My colleague, Jessica Adair, Chief of Staff, will be joining you in person shortly. She is currently stuck in the Assembly Judiciary Committee meeting, and I think we can agree that I got the better end of this deal this morning. Under current law, the Office of the Attorney General is granted exclusive authority to represent the state of Nevada on legal matters. There are, in fact, carve-outs where the office may retain outside counsel on a contingency fee basis when, quote, the Attorney General lacks the resources, skill, or expertise to provide representation in the matter that is the subject of the contract, or the Attorney General's office can also retain special counsel if representation by the Attorney General's office is, quote, impracticable or could constitute a conflict that precludes us from representation. Additionally, NRS 353-335 prohibits the Office of the Attorney General from accepting free legal services. The framework formed by these laws create a unique loophole where the Attorney General's office may not in fact lack the resources, skill, or expertise to litigate a matter, but we are unable to accept pro bono legal services from top experts in the field whose guidance may greatly aid the state. This bill is intended to close that loophole by allowing the Office of the AG to accept high-quality legal services or advice at no cost to Nevada taxpayers. For the purposes of this testimony, I will be referencing reprint 1 of the bill as passed by the Senate. The first substantive section of the bill is Section 6, and that section provides explicit authority for the Attorney General to enter into a pro bono contract for legal services when he or she believes it is necessary. Section 7 provides that the Office of the Attorney General shall remain the ultimate decision maker in all aspects of litigation or matters in which pro bono counsel is retained. This provision preserves the constitutional role of the Attorney General as the sole determiner of what is in the best legal interests of the state. Section 8 merely provides that the Office of the Attorney General shall promulgate a form that must be included in all contracts pursuant to this bill. Section 9 imposes an affirmative duty on pro bono law firms and attorneys retained pursuant to this bill to maintain billing records related to their work for a period of 4 years. These documents are public records, but the language of the bill provides that requirements should not be construed to compel the disclosure of otherwise legally privileged documents. Sections 10 and 11 are intended to provide transparency by requiring the office to, 1, post all pro bono contracts on our website within 5 days of final signature, and 2, provide annual pro bono activity reports to the legislature. Nested between sections 10 and 11, however, is a section 10.5 that was offered by our office as an amendment prior to the first work session in the Senate. Section 10.5 provides that any law firm or attorney entering into a pro bono contract with us is barred from entering into a contract as contingency or special counsel of the office for a period of 1 year after the completion of pro bono services. The Office of Attorney General is committed to bolstering public trust in our government, and we believe this amendment was an important addition to maintain the integrity of our outside counsel statutes. Sections 12 through 14 are simply conforming changes, and Section 15 of the bill amends the gift statute to explicitly allow the Office of the Attorney General to accept legal services as provided on a pro bono basis. That is the walkthrough of the bill. Before I close, I do want to thank the committee for your time and consideration of this bill, and I'm happy to answer any questions you may have.
Thank you for that presentation, sir. And with that, we'll open it up for questions. I am now checking the chat, and feel free to just turn around and let me know if you have a question. We'll start off with Assemblywoman Anderson.
Thank you, Mr. Chair, and thank you, Mr. George, for the presentation. I was just messaging one of my colleagues that the most difficult part of having this on no longer online is I can't figure out your book titles, but I'll watch that later. So very quickly, my first question, is this only for criminal or is it for civil as well? Is it for both elements?
I don't think there's a limitation placed on the language of the bill, but we do envision this as more civil than criminal. I think the need in criminal matters is certainly less than in civil, where there's a broader range of topics that may arise that we may not be as well versed in. I'm sorry, for the record, Kyle George.
Thank you, and thank you for that clarification. And then my second question had to do with the length of the 4 years, section 9 with the 4 years. What was the decision behind that length of time? Because sometimes we do have some litigation that is a longer time frame, obviously much more in-depth research and everything. So just trying to figure out what the reasoning was behind the 4 years after the date of the beginning, or a little bit more information about that decision.
Of course, for the record, Kyle George, First Assistant Attorney General. I'm sorry, I'm looking up at the bill, so pardon me for the lack of eye contact per se. I believe that is consistent with other public records or other statutory requirements to maintain records. I'm not sure the source of that time period that was provided by LCB, but we do want to retain the ability for the public to look back and see the activity that has been the pro bono activity that's coming out of our office or coming through our office. I don't know of any specific reason that 4 years was selected, however.
Thank you for the clarification. It's basically consistent with other statutes, and is what it feels like. So thank you very much, and thank you, Mr. Chair.
Thank you, Assemblywoman. Next, we'll go to Assemblywoman Thomas.
Good morning, Chair, and thank you for this opportunity. And thank you, Mr. George, for your presentation. I just have one question, and it's for clarification because I'm really not understanding Section 10.5. I was wondering why it was necessary to basically to not have a retained attorney or law firm from entering into a new contract with the AG's office. Thank you.
Thank you for the question, Assemblywoman. For the record, Kyle George. We added that after the bill was originally introduced because we realized there may be some concerns that some law firms are using this as an end run around existing contingency counsel and special counsel statutes. So under existing law, there's a bidding process that takes place for us to retain some kind of counsel. We open it up to the public. We make sure that everyone interested in such contract is given an equal opportunity to participate. What we didn't want to do is create the perception that law firms and attorneys can buy access to attorney general's contracts through pro bono representations. In other words, pay for play. We didn't want to create a situation where a law firm was offering free legal services on one matter, perhaps a smaller matter, and then subsequently getting an award for a large legal contract or a large contingency fee contract that would create a perception that they bought access to the Attorney General's office through their pro bono services. We thought the construction of excluding them for 1 year period, a cooling off period, if you will, would ensure that that type of situation doesn't arise and doesn't create some sort of mistrust that the contingency counsel and special counsel statutes were being abused.
Thank you, Mr. George, and thank you, Chair.
Thank you, Assemblywoman. Next, we'll go to Assemblyman Matthews.
Thank you, Chair. Thank you, Mr. George, and thank you for that last answer and for addressing those concerns regarding the potential pay-to-play situations, which obviously we want to avoid. I'm wondering if you could speak to whether there are certain policy areas where you have seen a particular need for this type of pro bono work, or if there are certain areas where you envision this need arising in the future.
Thank you, Assemblyman. For the record, Kyle George. Two specific circumstances come to mind. One, in the past few years, the state was engaged in litigation against the United States Department of Energy over plutonium that was shipped to our state. And that area of law is very specialized and not something we would ordinarily house within the Attorney General's office. That skill set is not ordinarily housed within the Attorney General's office. In that particular case, we retained outside counsel. But were there opportunities to get pro bono counsel and save taxpayer money, we would, in fact, have been precluded from doing so. The other circumstance arose more recently within the last year as collective bargaining came into effect in the state of Nevada. Collective bargaining was not previously provided for. Our agency was not previously involved in it. And for us to actively and meaningfully participate in collective bargaining, there was a steep ramp up of legal skills. We had to train up very quickly on an area of law that none of us had familiarity with. And that was one opportunity, for example, where consulting with experts in the field on a pro bono basis would have been helpful had we had the ability to do so.
Thank you. Mr. Chair, I've got a couple follow-ups, if I may.
Follow, please.
Thank you. Thank you for that, Mr. George. Do you know, are there other states that have this kind of allowance in statute? And if so, roughly how many?
Thank you, Assemblyman. For the record, Kyle George. I don't know the answer to that question. What I can promise you is I can find out and get back to you with an answer.
Okay, thank you. And then finally, I'm wondering if you have identified or anticipate a situation where, or if you can anticipate, the number of outside attorneys that may be ideally situated to perform the type of work you may be looking for, whether you envision this being kind of an array of, multiple attorneys who may be providing this type of work, whether there may be, one or two. What I'm getting at, my main concern with this may be that, this could result in sort of an unelected, unofficial, but semi-permanent extension of the office. Someone who is sort of consistently being used for these services and become kind of an official extension of the AG's office. And I'm just wondering if you can speak to that at all and what you anticipate there. Thank you.
Thank you, Assemblyman. For the record, Kyle George. That's a good question. The first part of the answer is that I don't anticipate this will be used a lot. I think this was really brought forth for the rare occasions that we don't possess expertise in-house. The Attorney General's office handles a wide variety of areas for the state. It's a rare occasion that something pops up that we don't have expertise in. Recently, for example, we had a bankruptcy matter that isn't really something we normally do So we had to comb through our staff attorneys to determine who had the skills to help assist in the matter. Honestly, I don't believe that we will have a standing shadow attorney general, if you will, for two reasons. One, the best use of pro bono services is to get our own in-house attorneys up to speed on the subject matter as need be. That certainly will prevent us from having the need for a long-term contract with them. The other part of the reason I don't think this will, in fact, create a shadow system is because of Section 7 of the bill, which does provide that the Attorney General's office does retain final say-so in any legal matter that through which we're getting assistance with pro bono counsel. I hope that's responsive.
Yes, thank you so much. Thank you, Mr. Chair.
Thank you, Assemblyman. Next, we'll go to Assemblywoman Brown May.
Thank you, Chair. Thank you, Mr. George, for that great presentation and the answer to that last question. Specifically, my question is relative to attorneys that you would utilize for this pro bono opportunity. Would they be specifically attorneys that are licensed here in Nevada, or would you have access to attorneys across the country?
Thank you, Assemblywoman. For the record, Kyle George. The language of this bill has no limitation that the attorney must be licensed in the state of Nevada, and I think that is purposeful. The expertise we may seek may not exist in Nevada, for example. There are some areas of law that are so arcane or so unusual that if we limit the bill to Nevada attorneys only, there may be no value to seeking their counsel. Their expertise on the subject may be equal to others. So I think for that reason, the bill would be more valuable to the Attorney General's office if we do have access to attorneys nationally. Of course, any filing in any court within Nevada will have to come through our office in such a circumstance, or the attorney would have to be admitted on a pro hac vice basis.
Thank you, Mr. George. Thank you, Chair.
Thank you, Assemblywoman. Next, we'll go to Assemblyman Ellison, please.
Thank you, Mr. Chair. I've got a couple questions. My first one is, how many attorneys are on staff at the AG's office now, do you know?
Thank you, Assemblyman. For the record, Kyle George. I don't know the exact answer off the top of my head. Within my line alone, I have 103 attorneys that report under my half of the office, and we have Second Assistant Rady. I'm not sure how many attorneys she has. Roughly, our office has about 350 personnel in total, but that includes support staff as well.
Okay, thank you. And then I know you hit on, my colleague answered about 9, and it says a 4-year contract. Legally, can they do that, enter into a contract when that's elected position by that office? So if I just got elected, I could appoint somebody for 4 years or hire somebody for a 4-year program. So if this is midterm and they hire somebody, can that legally stand up? Because you're in a contract for somebody else that might be there down the road.
Thank you, Assemblyman. I'm sorry, I didn't mean to cut you off. For the record, Kyle George. Let me find that provision of the bill, because my understanding is that the records related to that retention must be kept for 4 years. I don't believe. Assemblyman, what section were you referencing, please?
I was just looking at number 9 where it said, section 1, it said retain an attorney or law firm shall from the beginning of the term for pro bono contract upon the date not less than 4 years.
Thank you, Assemblyman, for the clarification. For the record, Kyle George. I believe that section reads that the records related to this work must be retained for 4 years, after which the contract expires. It doesn't call for a contract term that goes up to 4 years in length. Additionally, I would point out that any contract of, I believe that a contract of this magnitude would have to be approved by the Board of Examiners as well, which would provide, I think, some sort of oversight on the scenario that you described.
Thank you, sir. Thank you, Mr. Chair.
Members, any additional questions? Assemblywoman Dickman, please.
Thank you, Mr. Chair, and thank you, Mr. George. Just a little bit of a follow-up on Assemblyman Matthews' line of questioning. How difficult do you think it will be to find qualified attorneys who are willing to work pro bono for the state? What is the advantage to them? Just as maybe you could give me some examples.
Thank you, Assemblywoman. For the record, Kyle George. I can't think of any examples off the top of my head, but I think, generally speaking, legal experts take pride in their ability to say, I've assisted the Attorney General's office for the state of Nevada on this issue. For them, it becomes a selling point that demonstrates their expertise in the subject. Very often in matters we've litigated in the past, we've had firms offer to assist us whenever possible, and we obviously didn't take advantage of it because we legally could not. But off the top of my head, I can't think of a specific example that would really be illustrative on when that would happen. But I do know that in practice of law, offers of pro bono assistance isn't uncommon at all.
Thank you, and thank you, Mr. Chair.
Thank you, Assemblywoman. Members, any additional questions? At this time, I don't believe I see any. Thank you again for your presentation. And at this time, we'll invite those wishing to testify in support of Senate Bill 38. I don't believe we have anybody here who appeared in the committee room, so we'll go to those wishing to testify via phone. Broadcast, please.
To testify in support of Senate Bill 38, please press star 9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you, sir. At this time, we'll go to those wishing to testify in opposition to Senate Bill 38.
To testify in opposition to Senate Bill 38, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. And lastly, we'll go to those wishing to testify in the neutral position for Senate Bill 38.
To testify in the neutral position on Senate Bill 38, please press star 9 now to take your place in the queue. Chair, there are no callers in the neutral position at this time.
Thank you. Mr. George, any closing remarks you may have?
Thank you, Mr. Chairman. Not at this time.
Thank you, sir, for your presentation and for answering the members' questions. Members, thank you for engaging. At this time, we'll go ahead and close out the hearing on Senate Bill 38. And if we could have our Senate Majority Leader, if someone could please notify her that we are ready whenever she has an opportunity. I know that she's busy this morning, as always. So we'll go into a quick 1-minute recess to allow our Senate Majority Leader to make her way to our committee. 1-minute recess. Broadcast? We're ready to get back.
Chair, broadcast is ready. You may call the meeting to order when you're ready.
Thank you, Broadcast. The Assembly Committee on Government Affairs will come back to order. Good morning and welcome, Majority Leader Canizaro. Welcome to your hardworking Committee on Government Affairs. And at this time, we'll open up the hearing on Senate Bill 372, whenever you're ready.
Good morning, Chair Flores, members of the Assembly Government Affairs Committee. It is great to be here with you all on this lovely Thursday morning, and thank you so much for having me. For the record, my name is Nicole Canizaro, and I represent Senate District 6, which is located in the northwest portion of the Las Vegas Valley. I am here today to present to you Senate Bill 372, which revises the process of reporting burn injuries. Mr. Chair, with your permission, I'd like to give a bit of background, walk briefly through the bill, and then turn it over to Mr. Heenan and our doctors over at UMC to further explain the reasoning behind Senate Bill 372. By way of background information, and for members of the committee, burn injuries remain one of the leading causes of unintentional injury. In the last decade, Nevada's hospitals have treated tens of thousands of patients with varying degrees of burns. Healthcare providers work in conjunction with fire departments to report specific levels and types of burns as outlined in NRS 629.045. The Clark County Fire Department, for example, is the 7th busiest fire department in our country, and its personnel serve as first responders to aid many of these burn victims every single year. Because fire departments in Nevada are busy with numerous responsibilities, Senate Bill 372 seeks to refine the reporting process for certain burn injuries. While not all injuries are attributed to arson, there is still some level of investigation required in each case. This bill establishes steps that need to be followed after a burn injury occurs. Primarily, it extends the necessary time frame from 3 to 7 working days to report an injury to the state fire marshal. It also limits the type of burns required to be reported by the healthcare provider after treating a burn victim. And ultimately, what Senate Bill 372 will do is to facilitate a more focused, in-depth investigation into only those incidents that require it while lessening the burden on healthcare providers and first responders to report some incidences unnecessarily. With your permission, Mr. Chair, I would like to turn it over to Mr. Dan Heenan and then over to our doctors over at UMC to further provide some context for Senate Bill 372.
Perfect. Thank you, Senate Majority Leader. Please, whoever wishes to go first.
Good morning, Mr. Chair and members of the committee. My name is Dan Heenan. I'm the Assistant Fire Chief for the Clark County Fire Department, and I oversee the Fire Investigation Division. I've been employed by Clark County Fire Department for the last 3 years. Prior to that, I was a special agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly referred to as ATF, for 30 years. Within my capacity as an ATF agent, I was the certified fire investigator in the state of Nevada, and I worked with state and local fire investigation units in determining how a fire started, where it started, and why it started. I was also part of the United States National Response Team and became team leader of that unit for 20 years. That unit would travel throughout the United States and the world when there were large-scale fires and or explosions to assist the state and local counterparts in determining how, why, and where the fire started. Referencing this bill, Senate Bill 372, there are some changes that we'd like to make in Section 1. As the senator said, we'd like to move the reporting time from 3 days to 7 days. The UMC burn unit down here is one of the busiest burn units in the nation. And as such, the nurses and doctors have responsibility for the medical care of those patients. Changing that administrative reporting period from 3 days to 7 days allows the nurses and doctors to really concentrate on providing care to the patients rather than the administrative necessity of reporting to us within 3 days. All it does is it changes the form. Currently, there's a form created by the Nevada State Fire Marshals Association Department, that they have to fill out. We've had numerous meetings, sit-down meetings with the doctors and the staff over at UMC to formulate a more current form. Not only is it more specific to the type of burn injuries that we're looking at, but it also can be filed electronically. That form will be has been created by UMC, and will be farmed out and sent out to the various fire units, either Las Vegas Fire, Henderson Fire, North Las Vegas Fire, or Clark County Fire down in the south. And that way we can have a better response time to those needs. Additionally, it changes the type of burn injury to be reported as to open flame, explosion, or flash fire. And I'll sit back in a minute and let the doctors and nurses explain to you why that change is effective. But basically, the nurses and the doctors have a better understanding about whether the burn injury that's being presented lines up with the facts and circumstances as told to them by the victim of the burn injury. If the facts and circumstances don't equal, then they need to report that to us and we'll do further investigation. But many times, the type of burn injuries that they're seeing makes perfect sense and falls in line with the story that they were provided. And in those instances, we rely on their expertise to tell us that it's potentially something that we don't have to investigate. And again, I'll defer to the burn unit people to talk about those specific injuries. Finally, in section 2, which refers to current NRS 475.125, currently it says that we, as fire investigation divisions, when we receive information from a hospital, we shall investigate it. We'd like to change that word to may. That gives the managers of the fire investigation units the ability to manage their people properly, to manage their caseload of the respective fire investigation divisions. And that way we ensure that we're really focusing on if it turns out to be an incendiary fire, commonly referred to as an arson, we can identify those people and really concentrate on those focal points more specifically. That ends my little presentation. I'm happy to answer questions after the burn unit manager speaks to you.
Thank you, sir.
Yes, sir.
Thank you, Chairman Flores, the committee, Majority Leader Canizaro, and Chief Heenan. My name is Yasmin Conaway. I am a registered nurse with over 11 years experience in burn care, and I'm currently the burn program manager at the Lions Burn Care Center at University Medical Center of Southern Nevada in Las Vegas. Dr. Saqib sends his apologies. He was unable to make this hearing today. He's currently seeing patients in the clinic and is on call today, but this would not have been possible without him. By way of background, we are the oldest and only verified burn center in the state of Nevada, which means we provide the highest level quality care and still pursue ways to improve patient outcomes even after they leave the rejuvenating confines of a hospital room or seek the expertise of our outpatient clinic team. We are fully verified by the American Burn Association, the governing body for burn care, which also sets forth guidelines for best practices. And best practices is what we're trying to achieve here today. The changes proposed today will provide a more targeted reporting based on burn injuries caused by flame, flash, and explosions. Currently, the bill does not delineate any mechanism of injury requiring all types of injuries to be reported, including scalds, contact burns, and friction burns. So the person making soup that spills a pot of boiling water on themselves gets reported. The elderly person that checks the mail, falls on the hot sidewalk, and sustains a pavement burn from the hot concrete gets reported. Or the motorcycle driver that skids across the asphalt after a crash, sustaining a friction burn, gets reported. These injuries are required to be reported to the appropriate fire department for investigation. For some perspective on how many reports, with the current verbiage in this bill, out of the 1,396 patients we served in 2020, there were 290 patients that met criteria for reporting. Under the proposed language, that number would drop to 140 patients, representing over a 50% decrease in reporting. What does that mean for the front line? It allows for more efficient utilization of resources. At UMC, for instance, we have a multi-tiered process for identifying and abstracting this information for reporting, which can take upwards of 1 to 2 budgeted hours per day. A benefit of this change would allow the resources to be redeployed to critical aspects like patient care, outreach, prevention, burn education to first responders, and the community at large, all while still capturing the cases that warrant appropriate investigation. And another change proposed in this bill includes the use of an approved form by the local fire department. The updated form would integrate seamlessly with the changes stated earlier by allowing for standardization, flexibility, cooperation, and coordination amongst the affected parties. Given the benefits, I strongly encourage you to consider the passage of the revised provision of this bill. Doing so means you will be making a direct positive impact on how we use public resources, provide outreach and education, work within particular budget constraints, and benefit the health and well-being of all Nevadans and visitors. Thank you to the committee for your time. I welcome any questions.
Thank you, and I think I echo the sentiment of the committee. I know that this year has obviously been, better said, last year and the beginning of this year has been incredibly difficult for all the work that our first responders, medical personnel have been doing. So we just wanted to thank you for your tremendous efforts. We know that you have been the unrecognized heroes at times. I know we often say thank you, but it's not enough. So we just wanted to thank you again. And please say thank you to our doctor who couldn't be here today. Should never apologize for taking care of humans over presenting a bill. So thank you. With that, Senate Majority Leader, do you have any additional comments, or should we open it up for questions?
No, Mr. Chair, that concludes our presentation, and we'd be happy to take any questions from members of the committee.
Perfect. Members, I'm now checking the chat to see if we have any questions on here. I don't see any on here. I do. Assemblywoman Thomas, please.
Thank you, Mr. Chair, and thank you, Senate Majority Leader. I appreciate the presentation and for the presenters over at UMC and the fire department. My question, because of the way this bill, we know that we want less reporting of issues that concern the fire department, but my biggest concern are those other reports that should go out, those of abuse of our children and or elderly. Are we dropping those? Are those reports still to be made? And if they are, where are those reports going?
Thank you for the question. Through you, Mr. Chair, to Assemblywoman Thomas, and it's good to see you here in Assembly Government Affairs. Nicole Cannizzaro, Senate District 6. This bill does not change any of the required mandatory reporting statutes that would require reports for child abuse or elderly abuse that come in. And I think with respect to where those may be related to burn injuries that come into any of the healthcare providers, they would still be required where those burn injuries are associated with what you're seeing here, which is that open flame, explosion, flash fire that are not explained by something as simple as, and I think Nurse Conway mentioned, someone who spills hot water on their hand and that burn is consistent with that. Then that report would not have to be part of the investigation. But obviously where there's suspected child abuse going on or suspected elderly abuse, that would still very much fall within the reporting requirements of something that was non-accidental and would need to be reported not only to potentially the fire department, but also to the appropriate authorities for either child welfare or elderly supportive services.
Thank you, Senator, and thank you, Chair.
Great. Thank you, Assemblywoman. Members, any additional questions? I am looking around, and I don't believe we have any additional questions at this time. Thank you, Majority Leader. At this time, we'll go to those wishing to testify in support. I do have a note here that we had, I believe, Mr. Kane, who wanted to join us via video. Or in person, better said, but I don't see him here, and I don't believe he is logged in to join us via video. So what we'll do at this time is invite those wishing to testify in support of Senate Bill 372 to join us via phone. Broadcast, please.
To testify in support of Senate Bill 372, please press star 9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you. Next, I'll invite those wishing to testify in opposition to Senate Bill 372. Broadcast, please.
To testify in opposition to Senate Bill 372, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. And lastly, we'll go to those wishing to testify in the neutral position to Senate Bill 372. Please.
To testify in the neutral position on Senate Bill 372, please press star 9 now to take your place in the queue. Chair, there are no callers in the neutral position at this time.
Perfect. Majority Leader, any closing remarks we may have?
I just again wanted to extend my thanks to Ms. Conway for being here with us and for all of her hard work, especially, and I think the chair was so gracious of the committee to express our support for the really tough job that they do every single day and have been doing especially so in the last year. And also to Mr. Heenan for his work on this bill and helping to put together something that I think both makes sense and helps balance the needs of our fire departments and our healthcare providers. And again, just wanted to thank the committee very much for taking the time this morning to hear Senate Bill 372 and of course, as always, my generous thanks to you, Mr. Chair.
Thank you, Senate Majority Leader, and thank you for your presentation. And with that, we'll go ahead and close out the hearing on Senate Bill 372. Next on the agenda is public comment. I want to remind those of you who wish to join us for public comment via phone, we encourage you to call in. We want you to participate, but this is not a time to reopen a hearing. It's a time for you to call in and speak about general matters that fall within the purview of this committee. We want you to call, but please don't try to reopen the hearing. With that, we'll go to public comment. Broadcast, please.
To take place in the public comment queue, please press star 9 now. Chair, the public line is open and working, but there are no callers at this time.
Thank you. I thought we had somebody calling in, but I'm checking and maybe not. So with that, we'll go ahead and close out public comment. And members, tomorrow we're going to be meeting at 9 a.m. We have three bills that we'll be hearing: Senate Bill 72, Senate Bill 311, and Senate Bill 360. I anticipate Madam Vice Chair running the meeting, as I will be doing 2 bill presentations tomorrow morning. But please be prepared and give yourself an opportunity to review those bills, excuse me. And I know Assemblyman MacArthur will be there to help Madam Vice Chair, should it be necessary. And I'll pay the audit for today. Yes, our influencer of the building, inspiring the youth, sir, inspiring the youth. Members, thank you all for everything. This meeting's adjourned. Oh, excuse me, by the way, I need to do this now because I forgot to do it yesterday. And I intend to have a nice, wonderful dinner with our staff at some point. But I just wanted to say yesterday, I know we were supposed to do a quick shout out and say for Staff Appreciation Day, and I think it's titled differently. But I just wanted to say thank you to our amazing staff here in the Government Affairs Committee. I've consistently said that, and you all know how amazing they are. But I just wanted to, once again, yesterday I forgot to do it, but I just wanted to say it publicly today, and how incredibly grateful I am to have such an amazing group of folks around me and you all, and this committee would not be anything without them. So I just wanted to say thank you, and if I could adjourn in their honor. This meeting's adjourned.